Hello everyone. We're pleased to introduce our today's guest for the podcast. It is none other than Mr. Anil Kohli, who is a distinguished chartered accountant, advocate, and an insolvency professional with over 2 decades of experience in resolving distressed assets since the inception of Surfacey. Under the domain of Insolvency and Bankruptcy Code 2016, he has handled several high-profile assignments such as Moser Bear India Limited, GBK, Gautami Power, Winsome Yarns, among many other corporate insolvencies that he has successfully handled. And in the domain of Surfacey, he has actively worked in the assignments such as Kingfisher, PC Jewelers, PP Jewelers, J. Polychem, demonstrating his capability in navigating intricate financial and legal intricacies. And he is the designated partner of ARC Resolution Professionals LLP, which is a key entity among the ARC group, which has been actively working in the insolvency ecosystem since 2017 and has handled over 125 assignments.
Yes.
Hello, sir.
Hello.
First of all, thank you very much for taking out time.
Yeah, it's my honor to. Yeah.
Humble, sir. So today we want to discuss about the recent amendments. These were one of the most awaited amendments since a long time, and these were, I think, most of the amendments were due since a long time. So just here with this podcast, sir, I just did not want to cover about what exactly the provisions say, but also understand what was the intent behind this and what was actually going wrong in the market, in the insolvency landscape, that these amendments was necessary. And moving forward, we'll also discuss and take your opinion on what could have been better and what they got it right.
Sure.
Yes, sir. So I wanted to start today's episode by asking, sir, it's been 10 years since Insolvency and Bankruptcy Code 2016 came. This is the 7th amendment, and there have been hundreds of amendments to the regulations. So there are two ways that people are looking at it. One way is that within 10 years, where we have seen so many amendments, the one side of the coin is that we are evolving along with the market. We are understanding what the market needs, and the government is always ready to fix those problems, which is great. But on the flip side, are we just patching a ship that's just about to sink somewhere the other day? I mean, it might be a pessimistic way.
Too harsh. That is too harsh. So on this, what I would like to say is, you are right to some extent saying that yes, in 10 years, so many things done, but it can be called that way also, that government has been, doing so much. And this is the first time that it has been seen that any of the law is being taken so seriously, and the activity of the government is as and when required and so fast, whenever like 29A came in, and like some of the other amendments which were kind of 32A, or certain things which were like restraining the execution of the code. So those have been immediately acted upon. And second side, which you are saying on the flip side, that sinking ship, I would like to speak on that. That because first point you have yourself covered, but it's not like that at all. Because IBC, since being a part of the this ship, I would definitely not admit to that it is sinking ship. It is the most smoothly floating ship, though every ship, there are certain tides. Sea is in the nature of, a dynamic nature. There are definitely bound to be tides and, low tides and high tides in any kind of sea. And the ship has to flow on that water, howsoever troublesome it is. But this ship has made its journey so nicely. I think this is the bestest executed code. This is the bestest law in the arena of stress assets. This issue has been since so long, and maybe I should say since the beginning of the financial transactions amongst the humanity. So this stress thing has been there. There has been defaults. There have been always lending and defaults together. And government and law from time to time has tried to evolve. There was insolvency laws even prior to independence also. That British insolvency laws were there. Then later on there were recovery suits in the civil courts, and we all know the fate of that. How long did it take? Then there were this BIFR, so which also is a well-known fact. How did it sink, and how it was a debt recovery restraint, which I use for basically DRTs. That it's a recovery restraint tribunals, so not the debt recovery tribunals, but they are debt recovery restraint tribunals. So it should be DRRT. So I should not say like that, but actually it has happened like that. So there only the borrowers have been getting relief, and to the extent that mainly for enforcement of securitization. So DRT was not also that much successful. Then came that RDDB Act. So then came in SURFACI. That is definitely also a beautiful law, because generally the lenders get as a salvaging, I would say, because I call it a salvaging of position. The real monitoring starts from when you lend. At that time the lenders have to take precautions. At that time they have to be that much diligent and that much awakened that they should take all the precautions, at whom to lend, how much to lend, all those decisions, and the fate of the debt is written at that time. So what kind of debt, to whom you are giving, and how much quantum you are giving, so that decides what will be the fate of it. So if it is given blindly and without taking much precautions, that is from the first day guided. So salvaging SURFACI has been to some extent good. Now comes the next step, is IBC. So this law has performed the best in salvaging of that position. Some people see it as that we are recovering only this much of the percentage of claims. No, it should not be seen like that. When the law is about salvaging, it is definitely about revival also, but at the best, to the lenders, what it can do is, if whatever is there, the available resources, whatever is left over, how best it can come to the rescue of the stakeholders like creditors. So this law has, to that direction, done the best, because you see from the point of view of liquidation value. So liquidation value, we are recovering more than 166% of that in this law. So I don't think you can get better out of that, because you have only the assets. The lenders are left with the assets when there is a default in a company, when their debt is defaulted. So this is the best which you can do. So in that sense, this law has been most successful in those terms, and it should be seen that way only. And claims, as we also know that in one of my matter, 400 crores of the original debt, and now the claim is in a span of maybe 6-7 years only gone to 2300 crores. Okay. So and if I recover say 800 crores, it will be called you have recovered 33% of the debt. No, it's not like that. So basically it is double of the principal amount, or you can so see it from principal amount perspective, or the best is the evaluation of this law shall be the liquidation value. So that is the parameter, that's the best. So having said that, now coming, because I come to the rescue of this law, it is my bread and butter, so I will definitely defend it. So I will not call it a sinking ship. So these amendments, these amendments are the most welcome thing could have been ever done, and a lot of effort and application of mind has been done for this. It is since 2022 that the first time this exercise was started, and since then we all had brainstorming sessions of maybe hundreds of times. So with the various institutions and various forums where we have discussed about the amendment, and after a well thoughtful discussions and well thoughtful inputs from all the possible stakeholders of this arena of financial sector, I should say, not only the insolvency but the entire financial sector and the legal fraternity have joined together, including the government, to bring in these amendments. And I will definitely come about the quality and all, because it will come further. but definitely these amendments are at the right time, the best thing to happen. And it is a decade now. We have a lot we have learned out of what all is happening. So there was a dire need of these amendments due to certain issues of delays which are being called. So that is always has been there, the feature of the judiciary. So wherever judiciary is there, there are certain other things due to which these things happen. I will not only say that this is because of the fault of judiciary. Definitely infrastructural things are there, and all those so everybody knows. So because of those also these delays are there. Then to tackle that, there is a lot in this law. Then coming to certain judgments of judiciary. So rainbow judgment and all these have also created certain issues, so which this law has very beautifully tried to overcome. So this law is on the perfect thing on the perfect time. Yeah.
Thank you, sir. Your words are really encouraging for
Thank you.
professionals when we'll be entering in the market.
Yeah.
So you mentioned about delays, and I think that was the biggest pain point for most of the insolvency professionals that we talk who come at IICA. So here with the amendment, they have mandated the admission or rejection within 14 days. But sir, there's one issue that I observe here, and they've gone ahead and they've given a proviso that if there is any delay, the adjudicating authority can give reasons in writing for the delay. Sir, how is this different from the previous legal framework that we had for 14 days? Even earlier when IBC 2016 started, as far as I remember, it was mandatory even then. But then later, because of certain Supreme Court judgments, that shall be interpreted as may, and the same amendment was incorporated. So do you really think in moving forward, this amendment will actually reduce the delays, and we have and also do we have the infrastructure to support this mandatory 14 days time frame, sir?
So basically this, earlier, like you have rightly said, due to some Supreme Court judgment wherein it was held that this is a discretionary, provision and not a mandatory provision. So all this happened. Also because of a judgment of Supreme Court, where discretion was given to adjudicating authority to go beyond seeing the default. Vidarbha judgment. Okay? So that judgment has been very nicely here, because what's the difference this time? So because lawmakers also understand that we have done this and there is no use of growing, and this will be a subject of laughter only, that when it was there, what's new, like you have rightly asked. So what they have done to cover that is, now they have put in the law itself that the jurisdiction of adjudicating authority is only to see the default. So if there is a default and it is reported in IU, in the NESL, that means that is end. That is the end. Adjudicating authority, as per the provisions of this new law, cannot go beyond the seeing the default. Nothing else can be seen by that. So Vidarbha judgment has been fully taken care of, and this law has, I am very much hopeful, has rightly said that now there is no point wherein adjudicating authority should even go to the 14th day, because they don't need to hear from the the debtors. They don't need to hear, because the default, I use receipts and all. This can be shown by the financial creditor also, by the operational creditor also. So if once that is there, that the default has been proved, that yes, it is default is there, and also it is recorded in the IU, because proving of default was also another adjudication thing. So that has also been covered, that no need to prove you. If it is there in the IU, that means it's done. Adjudicating authority has to just see that. So it's kind of, I would say, clerical thing now. Only for the adjudicating authority, there is nothing left for adjudication. So not even required 14 days would be required. It may be only listing process which may take. So I feel that this time it is going to sustain.
That's very hopeful, sir, because that was one of the biggest criticism that we always heard.
So I am very much hopeful, because of the provisions have also been made like that. Yeah.
Sir, and now coming to section 10. So in section 10, now the applicant, that is the corporate debtor, can no longer propose an insolvency professional to act as an IRP. So, what was the necessity on the ground, from your experience, from your decades of experience, what was actually happening on the ground that this amendment was a necessity, sir?
So, see, I would say it's too much to expect when you say that the person who is going to bring in someone who is there to, having the control and having the authority to, cut him off from the business and, bring in some other management, and he would put in a very fair person, a person who is, who is going to act in an equitable manner. Definitely, as a human behavior, even as a human behavior, we all tend to, think of ourselves definitely first. And he also has the right to think. So he would like to bring in a person who will act more in his favor than in the, other persons like creditors. So this was, in any case, it was a wastage of time when he was bringing, and the creditors in any scenario, even in operational creditors matter, they are going to replace the resolution professional. The IRP 99% is not confirmed as RP in section 10 or even in section 9 applications, because section 9 also, operational creditors, sometimes the CDs do manage to somehow bring in an application from some operational creditor, so that somehow, he gets the liabilities cut off and, come out of his distresses and all. So it is too much, if we think that, no, these guys are going to bring some equitable person and who will act against them and bring in their avoidance transaction and bring in plans from other persons, and he acts in against his interest. So that way they have thought well, and unnecessarily time was being wasted in replacement and all. So they have cut it short and brought in the law itself that fine, let it be an independent, transparent person who handles the process from the beginning. And that is good also, once a person comes in, even as an IRP, much is already, gone for the RP, incoming RP, because I have replaced others in at least 15 processes. Much more than that, I think. So what I have seen is, when I get the charge of that, much have already been done, which is even, what I would have been from the beginning, I may have done it differently and may have been in a better position. I could have brought the CD to a better level of operations, or because there are certain things available at that time which can be, if the person mishandles it, does not handle properly, that are non-recoverable. Those things are sometimes, there is an irreversible loss, so which cannot be reverted back. So I would always prefer that I be there from the first day. So now that has come in the law, so this is, I think, a good step, nice initiative. Yeah.
So moving further, so regarding section 12A, so the amendment before was you could withdraw it at any stage, and 2018 amendment brought in section 12A. So now the 2026 amendment has mandated that if the withdrawal has to happen, it can only happen after the constitution of, once the COC is constituted, and or it has to be done before the issuance of the issuance of first resolution plan. So this might be a very short period, around 30 to 60 days. Sir, I understand the intent, but sir, at the same time, there might be genuine settlements which might fail just because of this timeline, sir. What do you think, sir?
See, firstly, I would say, why should even this situation arise that he needs to give a proposal now? He has an empty time, ample time before the proceedings initiate. So he has that time when the account shows irregularity signals. Since then, he has the time when he can approach the creditors and say that, fine, I am here, I want to clear the default. If the account has actually defaulted, that means something is wrong with him also. He could have cured the default, and if he's coming now for this settlement, that means he doesn't have that good of an intentions. This is, in my view, this withdrawal and all is a formality. It should not even have been there, is also okay, because he already had got, that means he is just being getting pushed because this situation arose, then only he came in line. So he, when there were signals, if he was genuinely interested in clearing of the default, in working with the, because creditors at that stage would have been in a better position, they were individually there. They would not need to have a committee of the creditors. That individual creditor who has put in this application, if he defaulted his debt, he could have approached and get it restructured. He had the and all the creditors, in my view, mostly all the creditors are always ready to welcome a person who is coming there to cure his default, who is coming there for restructuring. They will definitely welcome and get it done in a very amicable way. So if this situation arose, this is just trying to give him an opportunity. So that is, I would say, it is only in the interest of principles of natural justice only this is being given. And secondly, so firstly, it should not be have been there. That would have also worked, but it is there, fine. That is very nice that he is being given as a principle of natural justice. Here the language is that withdrawal should be before, within this period of 30-60 days. So withdrawal starts, from the day the applicant gives this application in Form FA to the resolution professional. So in my view, later on, maybe it will be held like this only, that the application is required to be given within those 30 days. Then the process is not in anybody's hand, not even the promoter or RP. Then it will go like as a process, maybe the voting. So voting, happening of the voting and going to the adjudicating authority, they can happen even after, in my opinion. Withdrawal should be within this period, means the initiation of the withdrawal. So initiation is by submission of Form FA. So the applicant can submit the Form FA within this period, so which is much of a time, ample of the time available. So that, for that, this is sufficient. Yeah.
Sir, and then coming to Section 30, sir, for the dissenting financial creditors. So the recent amendment from earlier framework, where the dissenting financial creditors should have gotten at least the higher of the whatever they would have gotten under Section 53 or whatever the resolution plan is giving. Sir, I understand here what was happening is that the financial creditors were always pushing for dissenting, were voting against the resolution plan so that they could get a better value. So now the language has changed to lower of the same, that is Section 53 or resolution plan. So, but here, isn't there a scope that genuine financial creditors who might be now forced to take an haircut, and even if they wanted to go against the resolution plan and they would not be able to just because of this amendment, sir? Or is that the cost of, is it the cost of achieving the greater good?
So firstly though, I will go with the second one.
Okay.
Second option for the cost, for the achieving a greater good. But here the point is basically the intent of this law. The intent is revival. The intent is to revive the corporator, to resolve the debt, and the intent is to come out of the stress. So for achievement of that process, that goal of getting, so there may be a little sacrifice also by some of the people, because if believe me, whatever I have seen till now, maybe you are right that maybe some 1 or 2%, 5% may be there who may be affected by this, but generally, what was happening was this was restraining because even the creditors, when they think commercially, they would always see that, oh, greater of the value, like you said. So greater I am getting in liquidation value. So why should I opt for the plan? So this was more of kind of discouraging the revival. This was more of against the intent of the code. This was against the achievement of the purpose. So I would say that, so in this way now, which has been done, practically we have actually resolved the thing. So now it will be more towards it was not there, it was not at all other than commercial thing which was being done earlier. It was totally commercial, that when I'm going to get more as a liquidation value, why should not I go for that? Then that makes sense also. So when a commercial is here, so but when the greater good is to be done, like you rightly said, so when we are there as a purpose, taking a purpose in hand for revival of a corporate debtor, for the greater good of even the other stakeholders, operational creditors are attached, even the workmen are there attached, so the industry is there, the economy is there. So if a corporate debtor is right, so many people achieve some bigger purpose, so many, it's a good for everyone. Almost everyone for that. So for that, even if 1 or 2% maybe definitely they are a minority, that's why, or whatever reasons, so may have to sacrifice something, but it's worth that. It's worth that, believe me. And we firstly need to discourage that purposeful dissent.
Okay.
The purposeful dissent was not good for the process at all. So that way, yeah.
So now moving forward with creditor-initiated insolvency resolution process, very exciting, it's something very innovative for Indian legal framework. IBC was supposed to be creditor in control model, and that was the speciality of it. And bringing in debtor in possession model back into IBC is very interesting, sir. So now, when we look at the global insolvency frameworks, United Kingdoms or US Chapter 11s, so there the trigger of insolvency is even the mere possibility of insolvency, we can commence the insolvency proceedings. The sooner we start, the more value preservation will happen. And even the IBC's intent was the same. Moving from SICA, from BIFR, we were following the balance sheet test. Now coming to the default test, we are looking at it as a early prevention. Sir, could we have tried, which is something in line with the global frameworks, that is the mere possibility of insolvency, and incorporated it in creditor-initiated insolvency resolution process? Did we miss that opportunity, sir?
Firstly, coming to your first thing, that other countries have a debtor in possession model, and India's specialty was creditor. So that specialty was specially kept in this law, because seeing the conditions of the country, and since the law was in infancy, India was not ready for because the attitude of the promoters and all. So how do they behave when it comes to in their hands? So when it was in infancy, so definitely it was thought that for now, in the beginning, it should be like creditor driven, so that let it mature. Now perfectly after 10 years, when we see that the law has grown up, the stakeholders have grown up, now we understand the things better. So now it was thought that fine, it is the right time we go towards the international standards. So this is a first step towards that. Now what you are talking about is the second step. So in the first step, what it has been done is, from creditor driven, we are giving a push to the debtor driven in line with the global practices.
Correct.
Now come to the default model. See, same thing, because in this country right now, the mechanisms to measure the trigger of insolvency is a little, it will be too harsh, so it will be too harsh, seeing the economic conditions also. So just then it will be so much too much to handle, too much to handle also. Already, when it was 1 lakh of a default, the trigger insolvency was triggered. So
Correct.
what was happening? So that was rightly brought into 1 crore. Maybe thanks to COVID for that, but not COVID is nothing to thank for. But this thing came in. Some things have come out very nicely also,
Correct.
like virtual, meetings and
Seriously.
virtual things. So these are some bad things also sometimes, do some good. So this is also one of that 1 crore wala, it came in that. So now second step may come in, which you are saying about the trigger of insolvency, but let's wait for another 10 years. So let us digest this first, and let us try that at least on the trigger of the default they should immediately do it. Because earlier what happened is, in the first 10 years what we were getting were the stuck up cases, which was stuck up for long. 90% of the CDs were closed businesses, shut businesses, long drawn litigations were going on. So those stuck cases have been resolved. Second will be, now the cases when instantly after the default has occurred, the cases are triggered, the insolvency is triggered. Third stage will come. So when your wish will also be accomplished. Yeah. So please wait for that. So you will definitely experience that. By the time you are also a matured insolvency professional, you will get to see that.
Looking forward, sir. Really looking forward, sir. Sir, now coming to creditor-initiated insolvency resolution process, another question. So regarding the moratorium, as the whole process commences without the intervention of adjudicating authority, there's no automatic moratorium that's taking place. And there's 30 days of time for the resolution professional to apply. So it's more or less, it's optional in a way, where the resolution professional has to apply to the adjudicating authority to claim moratorium. Sir, but in this gap, don't you think, sir, that the assets of the corporate debtor can be manipulated, or isn't this enough time that the value erosion can happen and a lot of avoidance transactions can take place, sir? Or is there anything else that I am missing when I'm looking at it this way, sir?
No, you are very right in that. See, yesterday we had a conference and we were discussing this. Section 58B, wherein which says, so now there are more to it, more troubles, which I am also foreseeing. Firstly, approval of 51% is to be taken. So as per the law, what it says is, 58B1 says, so at the time before the appointment of resolution professional, number one comes I says that 51% approval. Two I's, they say that he has to then consider the representation by the not only representation, issue the notice to the debtor, then consider the representation, 3 I's. Then number 4, it says that after consideration of representations, he takes approval of 51% for initiation of insolvency. Post that only he will come in, and then he will apply for moratorium. So that also will need approval of 51% separately. So now all these processes are going to be making it very long. In the resolution regulations, there is, I have suggested yesterday in the comments, what I have suggested is, they have now put it like this. They say even before issuance of notice, even for issuance of notice, he should take 51% approval of the creditors. So what I say is, so law doesn't say like that. It is definitely placed just before notice, but the law starts with that before appointment of resolution professional, he should take this 51% approval. So what the ideal situation could have been, that issue notice by the creditor whose debt is in default, because at that stage he should not be burdened with looking for 51%, because my default is there. I have all the rights to have the representation of the corporate debtor. Say what you want to say. Say about my default at least. Why should I need 51% approval just for issuance of notice? I should have all the rights. So for that 51% should not be there. He shall be well within his rights, because law is not mandating. Regulations are mandating it. That for issuance of notice also. Because in law, it's only that placement is like above the issuance of notice, it is placed that 51%, but it doesn't say for issuance of notice. It says for appointment of resolution professional. Then the regulations say, then notice issued, representation received. Now for appointment of resolution professional, again take 51% approval. What's the point? So at least notice may be issued, then representation received. Now I feel that representation is not sufficient for even for myself. I am not satisfied. Fine, now I will collect 51% of creditors, and I say, okay, I want to appoint the RP. Please give me approval. I get 51% approval. Initiate that insolvency. I appoint the RP. Then again for moratorium, application for moratorium, again I go for 51% approval. Then I go to adjudicating. Why we are making it so cumbersome? The intent of the law is just to reduce the delays. So this then for moratorium, adjudicating authority will take its own sweet time. So for declaration of moratorium, either it should be on receipt of an application, adjudicating authority will declare the moratorium. But that is also not there. Maybe they will also go into adjudication. So, and by that time the harm will have to have been done. So I am definitely sure this will be rethought. This needs a rethinking.
Yes.
This aspect of moratorium, because without moratorium it's nothing. Hey, you initiate insolvency, he is going to immediately sell each and everything. So he is going, and you won't receive anything out of that. Though they say RP will sit in the board, fine. Like now what I feel is this here they should involve the MCA also, wherein they should make it mandatory that those board meeting, the resolution passed without the presence of RP will be invalid and cannot be acted upon. So these kinds of things need to be brought in. Otherwise, when they say shall sit in the meeting and he can reject the resolution, but what if they pass without his being present?
True.
So if they pass the resolution, they will act upon it and they will sell the assets. They will take more credit. They can do so many things with such resolutions. So the MCA needs to come in, and this will happen. Because when they see the practical things, this is going to happen. Both your point and this board meeting and these things, they will have to make certain amendments. This is required and is going to come. So my opinion is they should take these steps in the regulations and also rope in the Ministry of Corporate Affairs and try to bring in some things in the company law regulations also regarding the board meetings, the resolution passed, wherein it should be put in that once the CIRP is initiated, it should be filed with the ROC. Immediately RP can have the authority, and then it should be written there in the ROC records like INC 28 that now it is in CIRP. So it is going to happen, but after a little sufferings and the few initial processes, so things will change.
I think even the rules of board meetings under companies act,
all this needs to be amended. They will need to amend, otherwise the harm will be done. So these things maybe in
carving out provisions,
they will definitely need to come in. Something will come, sure. I can
looking forward, sir, but it's still a good step that thinking beyond the conventional and the traditional way of resolving the company. It's good to see that they're taking bold decisions like
at
this.
least.
So now, moving forward with liquidation. Now, the major change that these amendments have brought in is that there's nothing no longer as stakeholder consultation committee. It's the COC which will continue to act as, will continue to oversee the liquidation process as well. So what was the intent behind this? What was actually going wrong in the market that this amendment was a necessity, sir?
See, but I have seen SCC. What is the difference, first of all? The difference is here in SCC, you take only the top 5 creditors, financial creditors who have relinquished their interest, security interest. Then you take in the operational creditors, then you take in government, then you take in the shareholders, these kind. None of the others, who are going to get were at all interested, because in 53, who is going to get? Only the secured creditors, and that too who have, so fine, to that extent it's fine that who has relinquished, they are only going to benefit out of all this. So there was no participation. Believe me, in 99% of my own matters in stakeholders committee, I have rarely seen an operational creditors participation, and unnecessarily the things were getting blocked because you were not getting the approvals. These government departments, when they come in, how would you get the approvals for such expenses, or for even for sale, for reserve price fixation, so many things. Financial creditors are aware of the process. They are aware of what is the pluses and minuses. They are the people who are actually getting affected, They affected positively and negatively both. So they are the people. So now rightly they have brought in the right people who are actually, so who all are in the COC? Financial creditors, and they are actually who are going to get it. Yes, the missing point will be definitely the workmen and employees, because they also hope for something in the liquidation. There in stakeholder committee they were there, but believe me, they were also not participating. There was no participation from the workmen, even in the stakeholders committee. Actual decisions were there only by the financial creditors. So whatever, because even for our pool, contribution, reserve price, every decision mostly we were dependent upon the financial creditors. So things have been attempted to be made easier and smooth, and so that the process goes smoothly and also fast, because liquidations have actually really failed the timelines much more than CIRP. CIRP, so at least we were getting the plans approved and all that, something was, but liquidations are being continued for years and years and not getting closed at all. So maybe this was one of the reasons. So with the COC's participation and giving more authority to COC, we can see some matters closing, and which is good for us too, because if a matter remains pending, we are also getting affected by that. Yeah, we don't get the further matters, when something is pending. Three assignments only can be taken for more than 1,000 crore, and most of my assignments are above 1,000 crores. So that we were affected. So now maybe with this, we'll be able to close the processes fast. Yeah.
So, and now one more question regarding the liquidation, sir. Now the amendments allow the COC to remove the liquidator with 66% votes, sir. So the liquidator has to act independently, during the liquidation process. Sir, if the liquidator is always, now he will be scared to take any decision, he will hesitate because he might be removed by the COC. Sir, what was the necessity for this provision once again, sir? Or could this have been avoided, and so that the liquidator can act more freely? Because the whole concept of the stakeholder consultation committee was that the liquidator can take decisions of his own, even again going against the SEC, but there were necessary compliances for that. But now, sir, what was the need for this, that we needed this particular provision where COC could remove the liquidator?
So you are seeing the one aspect. If I tell you, there are very drastic side also, wherein when this authority was being given, liquidators were independent, and they were not even, the consultation was not binding upon them, and they can do whatever they want to, and they were literally taking it that way, that hey COC, you are nobody, a creditor, you are nobody to guide me, it's up to me that you are. In one of the matter where I have been replaced, I am just telling you how far it can go. So the liquidator thought that yes, he is the king, he is the master of this game, so he can play. What he did is, when he saw some kind of advice or some kind of push from the creditor, secured financial creditor holding 85% of the share in the claims, when he saw that yes, this person is really, this institution is very troubling me, he filed a case against that institution that it is a related party, just because, I'll tell you the point, a creditor has a right, during the restructuring, they can rope in their nominee in the board of directors. So they just to monitor that the things are going right, and it is part of the restructuring proposal. He took this as a cause to make him a related party. That institution, that during restructuring, they have placed their nominee in the board of directors. That's why they are a related party. Now, this being the scenario, I am not taking them into SEC. They will remain out of SEC. I don't need any approvals because the SEC main person is not there. So now I will run the entire liquidation on as per my whims and fancies. For 3 years, he continued like this. My replacement application was filed 3 years back by 85% approval of this, not even 85%, even the other 15% also approved my name, 100% approval, my replacement file. But this person said that since 85% is a person who is a related party having a conflict, so their approval should not be counted
Oh.
And NCLT was holding my replacement. My being coming in
As a
was
liquid.
held up for 3 years. After 3 years, some new person may have come in the bench, or maybe what happened, I don't know. But that person now brought me in, and setting aside his application, dismissing the application. Arey, it's not related party at all. It's not at all related party, because it is only for restructuring purposes they have appointed that nominee in the board. This doesn't make it, which should have been done in the first instance. But 3 years it took, and within those 3 years he sold all the assets. Everything has, all the bad things have been done. So that is definitely required. This provision is very much required. So I am with my professionals, but these kinds of actions really affect us also. And we are also being seen as a, if there is an act of terrorism, who is suffering more? The normal public, the mango people. Because you are being frisked everywhere. You have to go through all the rigors. You have to stand in the queues in the airport, before the malls, because it is act of one or two persons, for which crores and crores are suffering. So this was happening. So for our own good, there has to be tight scrutiny of people. There should be a provision, definitely, so that people remain in control, profession goes in a dignified manner, and we also gain respect. And otherwise our profession is definitely, I would say, as of now, is being made to see, and also being seen in a not in a very nice eyes. So that always hurts us. So
Because
these
of
kinds of people definitely need to be thrown out of the process, and these controls are necessary, I would say.
So now, as you said, you came in as liquidator after 3 years when all the mess was already done. So how do you, I mean, it might not be the first instance, like you would have seen similar instances in your long career. So how do you handle these situations, sir?
Salvaging. I go for salvaging the position. I gather whatever best possible I can. So that person has the courage or the audacity of now filing an application that I should be paid fees on future realization also, because there are arbitrations of 3,000 crores in that matter going on with some government departments, and most of the departments are such where we are expecting recovery. But he says this new liquidator should not be paid the fees. I should be paid because I have filed these arbitrations and I have acted. See, and that is under adjudication still, so I don't want to say anything, but see the way people are doing. So, but for that, now I am trying to put in better professionals into the right places, so that those arbitrations can be handled nicely, so that we can work upon those things in the best possible manner. So that way I am trying to salvage the position, I would say. So, and to gather bits and pieces and try to build a castle, and again, for the stakeholders, whatever best. And I think first achievement is going to happen in some few days itself. We are going to get a good, realization out in that. So that way we try to do whatever best possible after seeing the gaps wherever they are. Yeah.
If there's any questions from the audience, would be happy to take.
Yeah, please. So, audience.
So with the recent amendments coming in, I would like to ask you this one question: whether does it solve the problem of operational creditors getting sidelined? Because in a lot of cases, we have also heard about the fact of intelligible differentia, where the financial creditors usually gain much more than the operational creditors. And for a lot of resolution applicants, putting certain amount of very minimal amount of money for the operational creditors only becomes a compliance. Like for a lot of CRP cases that I've worked on, we have realized that resolution applicants only provide operational creditors the minimum bare value that is enough to get the plan complied for NCLT. Now, does the new amendment solve this problem or look into this problem at least?
This aspect, I would sincerely say, honestly, has not been covered much in these amendments. and it was thought a lot that if something can be done about that, but the benefit that operational creditors get out of resolution, at least they can continue the business with the new management. So they get the opportunity with the approval of a plan that their principal industry is again alive, and with new people, maybe the people who can run it better, and they or their colleagues, in the industry may get benefited out of that. So this aspect of operational creditors is a miss in these amendments also. That has not very and also what happens, like I've already said, in this country we are not that much matured to the level that yes, if we bring in something for the operational creditor, this is going to actually go for their benefit. These kinds of things get misutilized also by some of the promoters who will bring in maybe the operational creditors who actually are not that. They can implant also sometimes, and that makes the things bad for the other genuine people also. Had the operational creditors, there would not have been any fear of there being ingenuine operational creditors. This problem would have been really tackled earlier it also, because then there's some provision. If we are sure that yes, there won't be any kind of implantation of operational creditors and to just spoil the process. So this there could have been some better solution for this. The only issue is that you cannot be sure of. You cannot be sure of that yes, the operational creditors there are genuine. Yes, like you are rightly saying, we must do something about the genuine operational creditors. Some thought process should be given. Maybe in my view, I have proposed sometimes, I have a solution. Even when these amendments were being discussed, I propose that in the section 53, what we can say is that above the liquidation value, if there is a realization in the resolution plan, the operational creditors should also be made party. So they should also be entitled to the share above liquidation value. For the secured creditors, you have already distributed them the liquidation value, what they have in their assets. They have been justified. They have been given justified distribution. But for keeping in mind the interest of the operational creditors, if they could have brought in these kinds of things, that at least above the liquidation value, operational creditors should also be a shareholder, that may have actually helped a lot and could have resolved to some extent, could have come to the rescue of the operational creditors. So this is my suggestion. Maybe sometime in next amendments. Yeah.
Thank you so much, sir.
Thank you, Yog.
Anything else? Yeah. Thank you.
Sir, just a question. Do you think even after these amendments, there is some issue which should be further addressed, or some issue which should have been addressed in this amendment itself?
So if I say that way, definitely a lot. So we cannot say that yes, much has been done, but like PF gratuity issue, that needed to be addressed. Somehow some clarity was required, like operational creditors issue, some clarity could have come. There are many more small things, which could have been taken care of, and maybe it's not the end. Maybe in times to come, so many things, because even the group insolvency and this cross-border insolvency, these things are they have made enabling provisions, but there should have been some more in the laws provisions regarding all these matters, because these are very important, cannot be tackled only by way of rules. There has to be something in the provisions of law which would have helped a lot even in enforcing these new mechanisms, and CIRP also. It cannot be only governed by the regulations or rules. Something more was required in the law. In times to come, when we learn more about all this, so they are already, like it was the first question, a lot is being done, and so dynamic law. So maybe this dynamism will continue, and these things will be covered.
Thank you, sir. One last question, sir. Regarding Section 29A, there are two opinions. One opinion is that it should continue. One opinion is that we can allow the erstwhile management to submit a resolution or plan or participate in the process. So, what is your opinion on Section 29A?
Like I have been saying, 29A, they have been allowed, but in any case, they can't say that we have the sources of fund. Had they have the sources of fund, that means they have money, then there should not be insolvency. So they would have settled their loan. So in any case, they are going to bring in strategic investors. So if we allow, even if we allow, and we tell them, okay, your role is to, in any case, bring some prospective investor, we welcome. Anybody bringing in some rescue for the creditor should be welcome. So in my view, promoters could also be welcome, so that because they can convince the other person. It's not that they can take over. Had they have the funds, then that means there is some kind of misdeed. So if they have the funds to buy back the unit, that means there was a misdeed. They were doing something wrong. They are having the funds and still there is an insolvency. Definitely there is an issue. So if we allow them to bring in the investors, there is no issue. I don't think that it should be restrained. Yeah.
Hello sir, final question actually. As I come from ARC background, I have seen certain amount of mistrust from creditors towards IBC. Would these amendments be able to address that issue?
Definitely yes. So mistrust is on two accounts. One is about the judiciary, where they see the delays, where they are helpless. Second is about the IPs. So definitely some of the IPs have done certain acts which have harmed the profession's dignity. So that way, but with these amendments, I should say the delay part definitely would be covered, and rest our regulator is taking care and trying to bring in the professionals on ethical grounds. So we are hopeful that yes, that trust will be built and they will be welcoming the IBC, and they have seen the outcomes. There is sometimes here and there in each and everything in life, and the goods are better. Goods are much more in this process than the bads. So that way I should see that say that yes, they should prefer IBC and would welcome it. Yes. Yeah. Yes.
So coming to, we are about to wind up the podcast. So before we close this, one final question, sir, for upcoming insolvency professionals like us, for young professionals like us, advocates, chartered accountants, company secretaries, whoever is in this insolvency ecosystem, sir, what would be your advice, and what would be that one quality that we should develop and that we can always count on, sir?
Ethics. That is the basic thing. If you are ethical, almost all other things can be taken care of. Only issue which comes in is when you have a different interest, your interest is different than what is expected, than what is required for the process. And when you think the other way, you try as to start thinking about yourselves and try to, mold the things in your, benefit. So that harms, and that is not long lasting. I would always say being ethical is the first and the foremost thing, and will solve almost all the problems, because there are so many advices you are going to get. But if you have certain other intentions, those all will be go unheard, and you will not consume them. You won't act upon them whatsoever anybody tells you. So when you have certain different intents, you are not going to follow the right path. If you are ethical, you are walking in the path which is required to walk. You will be corrected. You will be helped by many. You will get all sorts of help in development in your profession. So ethics is the basic thing. Character, because we say that if they say if wealth is lost, nothing is lost. If health is lost, something is lost. But if character is lost, everything is lost. So that you have to maintain. If that is there, you are going to succeed.
Thank you, sir. Thank you for that valuable advice.
Thank you.
We'll strive to always be better ethically, and we'll try to practice
Most welcome.
in the most ethical way practice.
You are most welcome to the profession. We
Thank
will
you, sir.
welcome you. Thank you very much for giving me this opportunity.
So
Thanks a
it
lot.
was our opportunity and our privilege to
Thank
discuss
you.
about
Thank
it.
you. Thank you.
We have discussed about everything, starting. Of course, we could not discuss all the provisions, all the amendments, but this is given. I'm sure that the viewers would get a very wide understanding of what was the intent behind this amendments and what is the way forward, and that there is an optimistic future ahead for us, for all the professionals.
Yeah.
So thank you for sharing
All
your
the
knowledge.
best.
Sir.
All
Thank
the
you so
best to
much.
you. All the best. Thank you.
Thank you, sir.
Okay. All the best. Thank you.